If you've just joined us, thank you for tuning in. This is Newslink on DSTV channel 403. So President Cyril Ramaphosa is defending the ANC's cadre deployment policy. He's responded to court papers filed by the Democratic Alliance. Now, Ramaphosa says the opposition party's case is premised on the state capture report, whose recommendations he has yet to consider. He says the DA's application is seeking relief not recommended by the Commission. What does this all mean? Does it cast doubt on Ramaphosa's commitment to fight corruption and implement the state capture report's recommendations fully? Well, let's discuss this now with legal analyst Benedict Phiri. Mr. Phiri, good morning and thank you very much for your time. You know, going through the President's papers 2 nights ago, there were quite a few interesting points. Now, as a start, he was cited in both his capacity as ANC President and then President of the country, but he has opted in this respect to respond in his capacity as President. As a start, what do you make of that?
You know, funny enough, I read it as him having actually put a statement that he's responding in this particular capacity because he hasn't been cited properly as president of the ANC. So that's how I read his statement in this particular affidavit. And I think that makes sense because if he hasn't been properly cited as president of the ANC, and you'll see that there are also a number of non-joinder elements that are raised by the president to say that the DA's application hasn't really joined all the parties that are necessary. But as president of the country, in this particular context, I think it's okay in the sense that he hasn't been cited as president of the ANC, particularly because the Public Service Act is being sought to be impugned as well, even though the relevant minister has also been cited in that respect. Yeah.
Then let's talk or get to the preliminary points. First is ripeness of hearing. The president is of the view that the matter was brought before the court prematurely. He actually went on to remind the court that, in fact, he was given 4 months after the final handover of that report. We all know that he can sit with it for 4 months, meaning that around the 22nd of October would be perhaps the end of that period for him to consider any action beyond that point. So he goes to make that point that if you're going to challenge or cite me, what are you challenging, because I haven't taken a position as yet? What did you make of that?
I think it's a good point in the sense that the court could consider whether we should first wait and see what the president does with the recommendations in the state capture report around this particular aspect. I think that particular point is linked to the point again around the fact that the DA has no locus standi in this particular instance, in the sense that this, or rather the recommendations of the State Capture Commission did not actually speak about declaring this policy unlawful, but actually recommended a separate body that would oversee the appointment of managers in government in a transparent and open manner. So I think those two go together, because he's saying, well, if I do implement the state capture recommendations around this body, then what is the requirement for this policy to be declared unconstitutional? There won't be a live debate in this particular matter. So just wait and see if actually I will implement that recommendation, because then I would have met the recommendation full on, rather than there be speculation as to whether the cadre deployment policy in and of itself remains unconstitutional.
But I want to take you back to locus standi. Now, if we're going to talk about their interest in this case, he goes on to also state that, nevertheless, cadre deployment is a policy agreed upon by members of the African National Congress. They enter voluntarily, and so for the Democratic Alliance in this respect should have no interest in the case. Is that now something that would be considered a general view that would hold in court, or you can have even ordinary civil organizations, civil society organizations that take an interest in what happens in particular political parties, or this matter around cadre deployment was to only be raised by members of the ANC?
So from the DA's perspective, for this to have been particularly compelling, what they would have had to show is the actual rights in the Bill of Rights that are being infringed by the cadre deployment policy. That would then afford them an ability to then set it aside. But as it currently stands in their papers, and the president takes exception to this, and he says that there's nothing that the DA has shown. There's no right that they've pointed to in the Bill of Rights specifically that the cadre deployment policy infringes. And as a result, them being outside of the ANC cannot then challenge a document or a contract between members of the ANC without showing more and without showing that actually outside of the ANC, this is the effect on the human rights or the rights in the Bill of Rights that are impacted. So I think, that is a good point that is well made by the president, in my view, because I think it is trite or well known that if you are going to rely on a challenge that supports the Bill of Rights, that has to be specifically spelled out, because the court has to go into a proper assessment of the ambit of the right, how it's violated, whether the conduct or the cadre deployment policy in this particular instance limits the right justifiably, etc. And without that, the court can't get into that kind of assessment, which it has to do in terms of the Constitution.
Now, beyond this, we've seen that on social media, many of those who have read both this affidavit by the president, his response, there's been that debate around the obiter dictum, where there are statements made in passing by the judges. Now, in this instance, they're saying that actually this was a state capture report primarily looking into the capture of the state, not necessarily looking into cadre deployment. But it became a topic, it became something that was then dealt with extensively. Would we say that whatever ruling was made or recommendations made on the cadre deployment then fall within what we would call then the statements in passing by the judge, the obiter dictum?
Yeah, and this is the big point of the challenge by the DA that the president takes. He says, well, on your own, as the DA, you have not established any independent standing facts that show, firstly, that the cadre deployment policy is unconstitutional, or secondly, that it goes against the Public Service Act, and thirdly, in the alternative, that the Public Service Act is not sufficiently shielded from the cadre deployment policy. And the president does that in two ways. He first says, well, if we look at the examples you have given, if we look at SARS, PRASA, Transnet, ESCOM, and the people you refer to in that particular instance, actually none of them were factually linked to the cadre deployment policy. And what you've relied on then is the recommendations of the State Capture Commission that actually have no relevance to this particular matter. And secondly, there's another question, an additional question, as to how much of that can actually be taken as fact by this particular court without the DA actually establishing its own fact in that particular aspect. So I think that will be a difficult part of this case for the DA to work on, because they'd have to have at least established that independently, and secondly, the facts that they rely on should then actually point to the relief that they seek, which the president has actually illustrated quite eloquently that doesn't really meet the test in this particular instance.
Mr. Phiri, it's always a pleasure to have you with us. Thank you very much for your time. That's legal analyst Benedict Phiri on this one. To this